Hey, everybody. Welcome to the breakdown. And one first, my name's Allison Gill. I'm really happy today to be joined by Steve Vladeck. And while we kind of give everybody a chance to hop on, I know everyone's probably hopping off of the Jeffrey Epstein survivors press conference and hopping on to join us to talk about, the looming invasion of Illinois. I just wanted to kind of give a brief overview. During a press conference yesterday, Illinois Governor J.B. Pritzker said he had information that Greg Abbott is going to be sending the Texas National Guard to Chicago, to Illinois. There's a military base. If anyone's ever been in the Navy, you're very familiar with Great Lakes. I went to basic training there back in the 90s in February. Don't do that if you're thinking of joining the military. And that apparently, on information and belief, J.B. Pritzker said he thinks that Greg Abbott is deploying the Texas National Guard to Illinois. Now, Greg Abbott has denied that in an interview with a reporter from the paper called The Texas Statesman. And so we're going to talk a little bit about that. So when we say apparent deployment of the Texas National Guard, that's what that's about. So how are you, Steve? It's great to see you, by the way.
You too. How am I? I am tired. Yesterday we started with Judge Breyer's ruling in the California National Guard case in the morning, and we ended with the Fifth Circuit Alien Enemy Act ruling at like 10:30 p.m. And it was just like, can't you all just like pick a time and just do all your decisions then?
Right. Or stagger them a little so that we may
Yeah.
sleep. Um,
It's almost like the Tuesday after Labor Day is when everybody's like, oh, we've got to get our workout.
yeah. And before we jump into the difference between the National Guard deployment in California, National Guard deployment in D.C., and this potential National Guard deployment in Illinois, that Fifth Circuit ruling kind of blew me away. Now, granted, the three-judge panel on the very conservative Fifth Circuit included, I think it was two conservative judges, a G.W. Bush, a Trump, and then was the third a Biden judge?
Yep. So, I mean, Judge Southwick is about as moderate as you can get for the Republican appointees on the Fifth Circuit. So it was actually a surprisingly balanced panel for the Fifth Circuit. But yeah, I think it was still a bit of a surprise.
Yeah, I was pretty shocked, and this comes from so everybody can kind of get an overview. Way back in March, there was the initial attempt to deport people to El Salvador under the authority of the Alien Enemies Act, and there were a lot of preliminary injunctions, a lot of TROs. The Supreme Court said you have to file habeas petitions in the jurisdictions where the folks are. You can't do a nationwide injunction because this belongs in habeas. And I don't believe that, but that's what they said. And so then those original five plaintiffs, I believe those original five plaintiffs, two of them in Pennsylvania, three of them in Texas, filed their habeas petitions. And despite all of the temporary restraining orders and preliminary injunctions, and even I think a permanent injunction in the Western District of Texas, that the actual lawfulness of the Alien Enemies Act was still being litigated. And I think the Supreme Court kicked it back down to the Fifth Circuit to say, tell us what you think. Was that when Judge Ho was like, I can't believe you're making me do this, or was that a different case?
That was this case. This was the same case where Judge Ho complained about treating the district court like a Denny's.
Yeah.
And it took Justice Kavanaugh pointing out that by law, district courts are open 24 hours a day, 7 days a week. But, whoopsies.
Yeah, and good thing they're open 24/7 because we recently saw the rendition of unaccompanied minors
Yep.
with Judge Sparkle Signanon, which has been reassigned to Judge Kelly because it was never actually assigned in the first place to prevent judge shopping. They do that. They assign them randomly. But I was absolutely I didn't think the Fifth Circuit was going to come back with the Alien Enemies Act is unlawful, but they did, and I'm assuming we'll see either an en banc or a Supreme Court. It'll get back up to the Supreme Court pretty quickly. But now that we've got a good chunk of people here, let's talk a little bit about Illinois. And first of all, I just want to say thank you, Steve, for your One First Substack, your work to make the Supreme Court accessible to us lay people. I have learned pretty much like 90% of my Supreme Court stuff I learned from you. Make me sound smarter, and I know that there's a lot of folks out there who read your Substack who are then able to take that information and speak knowledgeably about things that are going on, particularly with the Supreme Court. So thank you for your work on the One First Substack, because so much
Thank
of
you.
what I get, you'll hear me on the Unjustified podcast and the Daily Beans, and I'm always like, Steve Vladeck says, Steve Vladeck says. And you're definitely an authority in that area, so we appreciate it. So let's
Thank
dive into Chicago.
Yep.
Again, as I said at the top, J.B. Pritzker said that he believes that Greg Abbott is deploying the Texas National Guard to Illinois. Greg Abbott denies that. But talk for a minute about the difference between what I know, having been in the military, between Title 10 and Title 32, which is federalized and unfederalized troops, because we can use the example of California as federalized troops, which elicited that decision about the fact that it violated the Posse Comitatus Act. But then there's unfederalized Title 32 troops, which would be Texas sending the National Guard to Illinois. So can you talk about those differences?
Sure. So I think that the way I think it's easiest to think about is there are federal regulars who are always in federal service. And so when we talk about the Army, the Air Force, the Navy, the Marines, those are regulars. And then there's the National Guard. And if you're in a state National Guard, you're really wearing at least three hats. The first hat is known as State Active Duty, or SAD. We need a better acronym. But in that capacity, all you're doing is state stuff. You are, answerable to the governor of the state and the adjutant general of the state. You are doing whatever state law authorizes and whatever the governor orders. At the other end of the spectrum, Allison, as you know, is what we call Title 10 status. That is when National Guard troops are federalized. And when they're federalized, which is what President Trump did for about, I think it was 4,000 California National Guard troops in California, then you are legally indistinguishable from federal regulars, right? You are as if you were in the Army or whatever. There's this intermediate category, and the intermediate category, as is so often the case in the law, is where all the hijinks are, called Title 32 status. And when you're in Title 32 status, you are not technically federalized. You are still in your state capacity. You are still under the command and control of the governor and the adjutant general of the state, but you are used for federal training or other federal missions at the request, not the command, of the president or the secretary of defense. And so, that middle hat is what's really interesting about the Illinois example, as distinct from California, where we had federalized National Guard, and as distinct from DC, where President Trump used the DC National Guard, who he always controls because it's DC, right? So the novelty in Illinois is trying to apparently have other states send their National Guards into a state that doesn't want them without being federalized.
Yeah, and I think it's also important to note that there are benefits differences between Title 10 and Title 32 as well. I worked at the VA, as you know, for over a decade, and in order to be considered veteran or have veteran status, you have to be Title 10 for 24 consecutive months or 24 non-consecutive. I mean, it's very complicated. So it also informs how you will and whether you will receive benefits from the Department of Veterans Affairs. So an important distinction. And talk a little bit about, when we let's talk about Judge Breyer, right?
Yeah.
In California, and the violation he found of the Posse Comitatus Act, and that he was able to find that because these were Title 10 National Guard troops, and then after that, talk about what possible statute exists that authorizes Title 32, a state sending state National Guard into another state, because there's an article in the Constitution that seems to clearly prohibit that.
Seems to. Okay, so this is part of how all these pieces fit together, which is so the Posse Comitatus Act of 1878 is a federal statute that prohibits the domestic use of the military, of federal troops, for ordinary law enforcement unless specifically authorized by Congress or the Constitution. What Judge Breyer found yesterday is that not all of what the federalized California Guard was doing, but some of what the federalized California Guard was doing in and around Los Angeles did in fact violate the Posse Comitatus Act. That some of what the federalized Guard was doing was ordinary law enforcement, and the statute President Trump had relied upon to federalize them, Judge Breyer held, was not one of those exceptions to the Posse Comitatus Act. The reason why the Title 32 piece is really important, Allison, is because when National Guard troops are in their Title 32 status, they're not federal. And so, therefore, they don't implicate the Posse Comitatus Act. What that means is if it's legal to have Title 32 National Guard troops deployed, they can do ordinary law enforcement without running afoul of Posse Comitatus. Um, the statute at issue here is a statute. It's 32 USC section 502 subsection F2. It dates back to 2006 and the aftermath of Hurricane Katrina, and it was an effort by Congress to sort of do a good thing, but not be clear enough about the limits. So the idea was to provide authority for the president to basically borrow, right, state National Guards that were willing to be sent for things like border security, for things like, sort of federal missions that no one finds especially controversial, right, for hurricane relief. Contexts where using federal troops would raise legal issues that using borrowed National Guard would not. What Congress did not expressly provide for in 2006 is that both the sending state governor, which has to agree to this arrangement, and the receiving state governor have to consent. All the 2006 statute requires is the sending state's consent. This is the fight that we're now seeing in Illinois, right? Shouldn't the Illinois governor have to also consent before you can have out-of-state, unfederalized National Guard troops sent into their state?
Right. So do you think Trump here is trying to thread the needle because over in California he was smacked down on certain uses, crowd control, riot control, law enforcement actions of federalized National Guard, I should say. And so is he not, because it seems to me if he wants to send the National Guard to Illinois to do jobs that they're allowed to do, like under the Constitution and under certain, Article 4, which we'll talk about in a second, that he would just federalize them and use them for protecting federal property like he's allowed to do, like Judge Breyer said he's allowed to do. But is it because he wants to use them for law enforcement? And do you think maybe that Judge Breyer decision had an impact on whether or not he federalized or hasn't federalized the Guard to send to Illinois because he can't use them for what he wants to use them for?
So I have a hard time thinking that this administration will be dissuaded from acting in Illinois based on what one judge in California has said. Um, but I think your broader point, Allison, is exactly right, which is this is looking for loopholes. This is, the velociraptors in Jurassic Park testing the fences, where, the authority that I think would be the most obvious one would be to invoke the Insurrection Act, which everyone agrees is an exception to the Posse Comitatus Act, but which would be a big deal politically, and which would be challenged on the ground that the conditions weren't satisfied. And
it's
so
harder to prove to the court.
Right. So what I think we're seeing in what Governor Pritzker says is being contemplated for Illinois is an effort to figure out if there's some gray area, right, in between what happened in California and a full-on Insurrection Act invocation where the federal government could have its cake and eat it too, where it could bring out, what are, to most people on the street, indistinguishable from federal troops, even though they're unfederalized National Guard, and use them in ways that you couldn't use the Army without provoking a different legal fight. But, as we're going to talk about, there are legal problems even with this.
Right. And let's talk about those legal problems, because I think there are two main things that you brought up in your first post about Illinois v. Texas. And one of them is Article 4 of the Constitution. These things haven't been litigated, correct? Because it hasn't been, the National Guard hasn't been used in this manner before.
So it's been used under. I mean, I want to be clear. The statute has been used a fair number of times, but never in this context. Never where the receiving state governor was like, "Hell no." The closest we came, Allison, as you know, was during the George Floyd related protests in 2020, when this is how Trump had out of state National Guard troops sent to D.C. Um, but for better or for worse, D.C. is not a state. Um, and as you mentioned, Article 4 of the Constitution, right? Article 4, Section 4 has this specific requirement that the federal government be able slash required to protect states from what it calls domestic violence only upon application of the state government, right? Meaning only if the state asks. And so, even though it's never been litigated, I think there's a very good argument that Article 4 at least requires the consent of the receiving state, and that the statute at issue here, it's 32 USC 502 F2, should be interpreted to not authorize these kinds of deployments without the consent of the receiving state as well.
Because simply what happens if a state uses its National Guard to invade another state?
I mean, so this is what, when we peel away all these legal technicalities and we go back to first principles, you know, we don't spend a lot of time in civics talking about why we have a constitution as opposed to just why we're independent. Um, but like a big part of why in 1787 the founders wrote a constitution as opposed to just the Articles of Confederation that we had governing us, right, for the first, 7 or 8 years of our independence. Um, is that there was real concern that you had the risk of state versus state conflict, and that state versus state conflict, Allison, would threaten the whole country, would threaten the security of the country. Part of why the founders all agreed we had to have a Supreme Court was so that there would be a neutral arbiter of disputes between two states, a world in which the law would somehow allow for the governor of Texas to send his National Guard into Illinois over Illinois' objection, right? Without being federalized, just because the president said, "Oh, hey, I think it would be nice if you did that," is basically turning like the founding principle of the Constitution on its head, which is the states are not supposed to go to war with each other.
Mm-hmm. Yeah, that in an ideally. Um, so if Illinois decides to sue, they could sue
Yeah.
because for violations of Article 4, and they can also sue for something called the Emergency Management Assistance Compact. What is that, EMAC?
Yeah, so EMAC is an interstate compact. So these are agreements between one or more states, in this case, I think all of them. And this one was ratified by Congress in 1996. So it's federal law. And it basically pledges that states will help each other when they have emergencies. What's telling about EMAC is that it has specific provisions talking about using one state's National Guard during emergency conditions in another state. But Allison, it says upon, quote, mutual agreement of the states, unquote. And so, whether or not you could sue for a standalone violation of EMAC, or whether that just helps to explain why that Title 32 authority should not be interpreted to allow for a unilateral consent deployment in the space, right? The answer is the same either way, which is Illinois should be able to walk into a court. And that's the interesting question, which court, and sue, right, some combination of the federal government and Texas if this really goes the way that Governor Pritzker suggested on Tuesday it was going to go.
And which court brings me to the question. I think you just said the Supreme Court was created to be a neutral arbiter of conflicts between the states. Their whole existence, right, is something as an idea called original jurisdiction. That I guess what that sort of translates into is you had one job.
Yep.
Um,
You had one job.
So what? This is what you're here for. This is your big day. This is your Super Bowl. Supreme Court conflicts between the states. But it's also your Super Bowl, my friend, with all these decisions coming down. I mean, we talked about that before we hit the live button. But talk about original jurisdiction, because you mention in your article, in your one first piece, Illinois v. Chicago, You mentioned that the courts aren't wont to use it. They deign to they just don't use it very often. They seem to have morphed into something else and given themselves a whole different job. We
Yep.
can talk about that on another time. But what is the if Illinois wants to sue
Yep.
and go directly to the Supreme Court to use their original jurisdiction? How does that work? Why is that a thing?
So it's a thing because the sort of the idea at the time of the founding, and it's been consistent in the relevant statutes going all the way back to 1789, is that when one state wants to sue another state, there's no lower court that would be fair. Um, right? Like Illinois versus Texas. Like Illinois would want to be in Illinois. Texas would want to be in Texas. Let's just go right to the Supreme Court. So insofar as Illinois wants to go right to the Supreme Court, its avenue to do so would be to sue Texas and, but not or, right, the federal government, right? The Texas would have to be on the other side of the case. I think there's a good argument for suing Texas. I mean, right, that whatever else Trump is doing, and to whatever extent he's responsible for this, wouldn't matter if Abbott said no. And so, the fact that Governor Abbott, according to Governor Pritzker, is in on this would be a reason to sue Texas. Now, there are downsides. As you mentioned, the Supreme Court doesn't like to exercise its original jurisdiction. It hears about one of these cases every 2 years, and they're usually about much less important stuff, like, allocating the water outflows from an upriver dam. But, right, we have a recent example from 2022 where New York sued New Jersey and was able to get the Supreme Court to issue a preliminary injunction. So the court actually moved fairly quickly. One other piece of this, Allison, as you know, Justices Thomas and Alito are actually on record as thinking that the Supreme Court doesn't have any discretion to not hear these kinds of cases. That if one state sues another state, the court has to hear these cases. So even though I don't know that they'd be especially sympathetic to Illinois on the merits, that's probably 2 votes for taking this case at this juncture. It's not the only option. Illinois could sue, Secretary Hegseth in federal district court, including, I think, almost certainly in Chicago, right? Illinois could sue Governor Abbott as opposed to Texas and try to argue that he's the proper party in federal district court. But, it seems to me that if the choice is Governor Pritzker deploying the Illinois National Guard to prevent the Texas National Guard from exiting the military base, or having the courts work this out, forgive me for thinking we're all better off having the courts work this out than putting 2 National Guards, within shooting distance of each other.
Right. Now, is it possible for Illinois to file multiple lawsuits in multiple venues? Can they do the original jurisdiction and sue Hegseth and like drop multiple lawsuits and see which one works?
This is yes and not either or. Yep. And so, there, I think, right, if Illinois were to try to do that, the federal government might try to intervene in the Supreme Court and say, well, hey, let's just get this over with here. But that's fine. I mean, to me, if the legal analysis is as clear cut as I think it is, right, if it really is not the law that one state's National Guard, without being federalized, can be sent into another state without their consent, seems to me we're all better off having the Supreme Court confront that sooner rather than later. And, I understand, I think, as well as anybody, why folks have reason to be cynical of this Supreme Court at this moment. But it seems to me that this might be a case where actually, forcing the court to move quickly would actually be a good thing. And, I think would hopefully diffuse what to me is a very dangerous potential scenario on the ground in Chicago.
Yeah, agreed. I'm thinking of another time a state sued a state. It was Texas v. Pennsylvania. And we all know what happened to that case. Does that sort of apply here and why that case got tossed out?
Yeah, so just to nerd out for a second on the Supreme Court's original jurisdiction. So, I mentioned the Thomas Alito view that the court has to take all of these cases. Since the 1970s, a majority of the court has consistently taken the position that it doesn't. That even when the opposing parties are states, where there's no other place for the case to go, that doesn't mean the court has to take up their case. And so, you mentioned Texas versus Pennsylvania. This was the really preposterous lawsuit filed by Ken Paxton in December 2020 that tried to get the Supreme Court to basically throw out the election results, not just in Pennsylvania, but in Michigan and Georgia. And I think Wisconsin was the fourth state. And the court denied leave to file. The court said, we're not going to take this up at all. Um, they could do that here too. I will just say that there were procedural problems separate from how preposterous Paxton's suit was, right? It was not the right kind of lawsuit for one state to sue another in the first place. This really would be, right? I mean, sort of whether one state can send its National Guard into another state is the kind of state versus state dispute, right? Whereas what Paxton was really complaining about was individual voters mad at four different state election officials' administration of their state election laws. So, Allison, I would never guarantee that the Supreme Court would take up this case, but I think there would be a decent chance if things escalate, right? If what Pritzker suggested at his press conference turns out to be what's really about to happen in Chicago, that one, Illinois will try, and that two, the Supreme Court might give them, at least the full time of day.
And a little bit of fun history about Texas v. Pennsylvania. Trump himself intervened in that case as a candidate for president, which was used against him in his immunity argument because they were saying the whole point rested on whether or not he was a candidate or whether he was acting as president, and he kept arguing that he's the president and he can do whatever he wants. And Jack Smith in court was like, yeah, but here you said you were a candidate for president when you intervened in Texas v. Pennsylvania. We never got to the merits of that, but and here we are. But I think that's a little bit of interesting history that it just didn't have original jurisdiction. So to wrap up, what do you think Illinois is going to do here? Or what would you expect Illinois to do if in fact the Texas National Guard is being sent? Because Greg Abbott is denying that it's being sent. I mean, that's pretty easy to prove or disprove, right?
So I think the first thing to do is to wait a beat, right, and to sort of to see what develops on the ground. To me, sending the Texas Guard to Great Lakes isn't necessarily itself the legal violation, right? Because Great Lakes is a federal enclave, and so putting troops on a federal base isn't yet violating Illinois sovereignty. But I do think that once it is clear that this is about to happen, Illinois goes to court. And I think the question is just which court and against whom. We've laid out some of the options. There might be others, but I would think that Governor Pritzker and his team will have every reason to want to litigate this, not just in the court of public opinion, but actually in real courts, because I think they've got the legal arguments on their side. And frankly, I think they've got principle on their side. And, part of why we have courts in this country is so that disputes are resolved without violence. This is, as clear cut, plain vanilla an example of that potentially being where we are as you could think of.
And if they do federalize them and send them there and have them protect federal buildings, do they still have a case arguing the necessity or the emergency that requires it? Which hasn't been, I don't think that's been litigated anywhere yet.
It's a different lawsuit. It'll depend on which authority President Trump would rely upon to try to federalize. But that, to me, is less crazy at that point, right? Then this case looks like the case that Judge Breyer decided yesterday. Then we're talking about the statutory limits of federalization authorities, right? Not the ability to send unfederalized National Guard troops from one state into another. And so I don't doubt that Illinois will still challenge that, but I think that the temperature would go down quite a bit if that's where this ends up.
Yeah, I mean, that you almost have a colorable argument there, as it seemingly they did when we look at the narrowing of Judge Breyer's decision.
Right. I mean, even Breyer, right? Even Breyer says, a fair amount of what they did in California was perfectly legal, right, under the relevant authorities. And that could be true, too, in Illinois, if that's the route Trump goes down, right? That's, I think, what we need to watch for in the next couple of days. If this turns into a thing, what is the exact authority argument? And if it's Title 32, I think we've laid out why that's deeply, deeply, deeply problematic.
Yeah. So it seems like the motivation is Trump could do this the right way, but he wants to push the envelope and see what he can get away with the courts.
Well, and because I think the right way has its own problems, as Judge Breyer's ruling underscores. And so I think the question is there a wrong way? And hopefully the answer is no, but we don't have the precedent for that.
We do not. All right, my friend. Thank you so much, everybody. Hit the heart button there. It helps with the algorithm. And please, if you haven't, subscribe to One First. You can also subscribe to my Substack. You probably already do. It's Mueller She Wrote, but you can subscribe for free to both. And then if you have the means, you can always become a paid subscriber. We'd appreciate that too, so that we can continue the work. And your work is so important. I wouldn't understand half of this stuff if it weren't for these amazing pieces that you write on One Face. I appreciate your time.
I appreciate yours, AG. It's great to be with you. And it's always, 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 I mean, one of these days you and I will sit down for a conversation that's about something that's a lot less depressing and serious.
I look forward to it, my friend. All right,
Likewise.
everybody. We'll, again, subscribe and we'll see you soon. Thanks so much for watching.
Bye, everybody.